Welcome to this free immigration help channel. Today is March 23rd, 2023, and we are getting into volume 40 of me going through your comments and questions and answering all of them. Now, I have already done one video today, volume 39, answering previous comments and questions, so today is going to be two videos because I did get quite a lot of questions in the past few days, so I have to catch up. Before I begin, as always, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in my videos on this channel are directly from official government sources, USCIS, and we are actually on the petition for alien relative, there you go, homepage, and the Department of State, of course, visa bulletin as always. So let's start with the very first comment from Ireland, 1968. My brother was 35 when I applied for him, now 48. This is a stupid broken system run by people who are proud of their career incompetence. If it was a business, it would have been shuttered years ago. Good luck. Ireland, 1968. I can definitely relate. In fact, I do have my own petition for a sibling, and I have a lot more. I mean, you have about another 3 more years to wait. I mean, yeah, it's ridiculous. You already waited for 13 years, and you will have to wait another 3-4 years because the backlog on the category 4. If we take a look at the visa bulletin, and this is the most recent one from April 2023. Category 4 for brothers and sisters of adult U.S. citizens is they're processing now in April. This is documentarily qualified. This, if you want to learn more about the visa bulletin itself, check out the video that I have uploaded. It's called Understanding Visa Bulletin. There I talk about these dates, what they mean, these graphs, and the different categories. But the F4 category for all chargeability areas is about, let's see, 2007, so between 2023, and my math is not the most fantastic math out there. 2023 minus 16 years 16 years delay. So Ireland, 1968, been waiting already for 13 years, so about 3 more years he'll have to wait until his brother can come here. So he'll see him around when he is around 51. It is completely ridiculous system, so 100% I agree with this comment here. Will it be ever fixed? I don't know. Why? Because we do have people who are proud of their career incompetence in the politics. That's just a fact. All right, let's move on to the next comment from Freewood Demici. Please, if you can ask about this RSC Africa caseworker. Okay, Freewood, I'm actually really glad that you followed up on this. I actually did my research on RSC Africa. Basically, it's the in Africa, it's a resettlement. I think it's a resettlement service center or something along those lines. Basically, that accepts these refugee applications, and it is, in fact, yes, it's an official organization, and it is sanctioned by the U.S. government. So it does work in cooperation with U.S. government. It is sponsored by an organization called CWS, I believe, Church World Service, something like along those lines, which is a non-profit organization. So it is a legit organization. So with that being said, however, I wouldn't put too much trust into them. Why? Because whenever it comes to non-profit organizations, just like whenever it comes to politics in general, Congress, people making decisions about the immigration reforms, a lot of times with these non-profit organizations, especially the ones that are worldwide, especially the ones that are big, it's at the end of the day, it's just a business. Yes, it is non-profit, but they still pay salaries. They still accept money from, the grants from U.S. government. They accept donations from all over the place. So they have these huge budgets, and they do cut out here and there for certain things. But at the end of the day, if you look at their financial statements, you will always see that this is ran like a business. Why? Because at the end of the day, it is a business. So with that being said, getting back to your case, I wouldn't put too much trust and just rely and just wait for, whatever happens. I would recommend doing a little bit more research on processing in general. That's kind of a homework for you. You would have to find out typically how long these cases do take. Now, the best case, you can always reach out to them. You can always contact them and ask them directly. I've seen on there, actually on RSC Africa, there is actually a place where you can enter your case information and the password, and it shows you the case status. So definitely do that. If you can come back and let me know in the follow-up comment what it says when you enter that information, that would be very helpful. Reach out to them, see what they say, how they are on the phone. And another thing that I would highly recommend doing, if you can find someone who is participant of the same program that you are in, maybe who has been already approved, maybe whose case is already on the next stage, right? Because once it's processed with RSC Africa, it is then transferred to USCIS for further processing. So if you can find someone who had their case already transferred, it would be very helpful. That's why I say on this channel, probably one of the best resources is whenever you can communicate with other immigrants that are in similar situation that you are in. So let's say if I have a case, for my brother, a petition for my brother, and I'm not, familiar with visa bulletin, and then I see someone like, for example, Ireland, 1968, talking about his brother and how long he's been waiting, that already gives me an idea, even though I do not understand visa bulletin, but it gives me an approximate idea how long these cases are taking, how long they are being processed. And it's not that you can do anything about it. Like, for example, in Ireland's case, can he really do something about this? No, not really. Until the immigrant visa is available for his brother, there's nothing he can do. But in the meantime, he can search for different avenues to at least have a normal relationship with his brother, to have his brother come over to the United States and visit him, because after all, he is a U.S. citizen, and as a U.S. citizen, you can invite your siblings to come here on at least non-immigrant visa so that they can come and visit you, right? It's common sense. So while you're waiting for that petition, yes, it's a long time, but at least you have all these different avenues where you can at least partially reunite with your family. So in your case, free award, that's probably would be the best thing that you can do, is you ask directly from the RSC what's going on with your case, and then you ask around from the community and see how long typically these cases are being processed. All right, let's move on to the next one. Actually, you know what? I'm going to post this right here. And I'm going to post this right here so that I do not forget, because sometimes I do. Next question is from Ivan Martinez. The question is, if the sponsor never lived in the States and has a green card, what happens? Okay, Ivan, excellent question. Thank you for asking. So whenever it comes to the sponsor, one of the number one requirements is that the sponsor has to have a domicile in the United States of America. Without that, you cannot do it. What does it mean? The domicile means that as a legal permanent resident or a U.S. citizen, whoever the petitioner is, right? Because you can petition for certain relatives as LPR, and you can petition for certain relatives as a U.S. citizen, all right? But that means that your main place of residency is here in the United States, which means you have your address, you have some kind of work, some kind of... Now, there are exceptions. For example, active duty military. If you're serving and if you are out of the country, somewhere else, that is the only exception that is allowed whenever it comes to sponsors. It's both. It's for a sponsor and for joint sponsors. But for a main sponsor especially, you have to be here in the United States. You have to be domiciled in the United States in order to be able to petition, in order to be a petitioner, a sponsor on the I-130 petition. So, to answer your question, if they never lived in the United States, then they won't be able to file this I-130 petition, and that's one of the things that you will have to figure out. If that's your situation, that you will have to figure out, whoever the person is, they will have to actually come here, and they would actually have to establish their domicile presence in the United States of America. Moving further from Miriam Art, response, they can lose their green card from my understanding. That is correct, yes. If there's a certain timeline for how long you can be outside of the United States with the green card. Typically, it's not recommended to be outside of the United States more than for a year. They have recently extended this time, and it became a little bit more flexible, and they did it due to the whole pandemic stuff that's been going on. But nevertheless, I would not recommend being out of the United States. If you just have the permanent residence, the green card, I don't recommend being outside of the United States for longer than a year. Why? Because regardless, whenever it comes to the process, legal permanent residence is really what it is. It's a permanent residence, and this is the time where you establish that United States is really your home. You really live in this country. This is really your country, and you are not planning to live anywhere else, right? So in 5 years of having the green card, permanent residence, you then apply for a citizenship. So naturalization. If you end up applying for naturalization, you might have problems if the person has been out of the United States and they fail to establish that United States really is their home. So it's, besides filing the petition I-130, you also have to keep in mind the naturalization process as well. So let me do that, and we're going to move on to the next question from Disa Patel. Hello, how long it take to convert F2A to IR1? How can I convert it? Okay, great question. So whenever it comes to conversion from one category to another, and a lot of times it happens if you, let's say you file for a spouse, right? You file for a spouse as a legal permanent resident. Because, especially now, because there is such a delay in processing just on USCIS side, not even talking about the NVC side, but because there is such a delay, it became quite frequent that while you're waiting as a legal permanent resident for your petition to be processed, you actually become a U.S. citizen. And as a U.S. citizen, this process should be taking faster, most of the times, at least twice faster. So it's significantly faster. So it's definitely in your interest to update it. So whenever it comes to updating the status, it depends on where the petition is. If it's still with USCIS, you will have to reach out to USCIS. The best thing to do is just call them. Call them, and I'll show you how to find the phone number. This is the official USCIS government website. So we're going to scroll down to contact USCIS, learn about USCIS contact center, and USCIS contact. See, they try to make it as hard as possible to find the phone number. Online, no, live assistance. That's what we need. And here you go. Here is the phone number. So call this phone number. Let them know your petition, your case number, receipt number, whatever it is, whatever information they request, and tell them that your status changed and you need to update the status. Now, most likely what they'll tell you to do is to send a cover letter with the initial evidence showing your status change. So you will have to attach your permanent residence card, your green card, copy of it, obviously, not the original, and also attach your naturalization certificate showing that you are now no longer a permanent resident, you are now a U.S. citizen. And then the cover letter, obviously, addressed to USCIS from you, date, your case number, receipt number, all the identifying information, your name, obviously you saying in kind of little essay, a few sentences, hello dear sir or madam, my name is blah blah blah, I am date of birth this and that, passport number this and that, again all of the identifying information, the case identifying information, and then telling them what you are requesting, why are you sending these additional evidence. And that's really it. And the same thing with the NVC. If the case is not with USCIS but is already with the NVC, then you would have to contact NVC, National Visa Center, and update it over there. Now, usually whenever it comes to the requests to change status, they do take some time to process. Typically, in the ideal, it's about a month and a half, but because there is a delay across pretty much everything, They are taking longer now. So now it's about 3-4 months you're probably going to be waiting for this to be updated. So let me do this, and we're gonna move on to the next one. And if anybody has any follow-up questions, feel free to ask them in the comments below. Just make sure to please submit it as a separate comment and do not respond to my comment here, because if you do respond, for some reason YouTube does not send me the notification, so I don't see those. I don't know why. All right, let's move on to the next one from Siftain Abbas. I hope I'm pronouncing this correctly. Sorry if I'm mispronouncing it. How long I-730 takes to interview when it's sent to embassy or consulate by NVC? Okay, great question. So whenever it comes to really both I-730, I-130, whatever petition it is, once it is approved by the NVC, once it's documentarily qualified and is sent to US Embassy, typically within a month, within 30 days, you get a notification giving you the date of the interview, and the interview is usually scheduled 30 days ahead. All right, so if you've been documentarily qualified and the case have been transferred to the US Embassy, and the US Embassy is not busy, because some of the US embassies, they are depending on especially now, again with this whole pandemic, typically they were not as busy, especially whenever it comes to immigrant visas. They were never as busy, because in the one particular US embassy, there is, compared to non-immigrant visa interviews, immigrant visas, it's usually it's not bad at all. All right, but now there are some delays, and it might take about 3-4 months. I've seen some cases where it takes 3-4 months if the US embassy is busy. But let's say they schedule it. Let's say you get the notification today that it is scheduled. The scheduled date is going to be about 30 days ahead. They give you about 30 days so that you can do your medical stuff in advance. And my recommendation here, if I can add something to be more helpful, is to do that medical examination as soon as that interview is scheduled. Don't wait to the closer to the interview. Do it as soon as possible. Why? Because there needs to be time for a doctor to transfer that medical information to the US Embassy, so that when you go for an interview, whoever is taking your interview, the consul at the US Embassy, they already have that medical packet from the doctor, from the civil surgeon in front of them. Okay, so I'm gonna do that, and we're gonna move on to the next comment from SS. Hi, I got my case approved. Congratulations. I got an invitation for interview. Great. Immigrant's visas. Perfect. From the embassy. A problem is when my father applied my I-130, my marital status was single, which is false. I got married, but I didn't tell him about the marriage. Now I don't know what to say to the embassy. Should I say that I'm still single, or truth? Will the embassy find out? Any suggestions? Wow, that is very, very interesting situation. Very, very interesting situation, because it's not really okay, there is a little bit of your fault here too, that you did not update your father. But again, I don't know the situation, your relationship with your father. So maybe you didn't have a choice, and or maybe he rushed. I don't know. The thing is, the case has been already processed. Okay, so here's the situation, right? Let's say you don't say, which I never recommend. I mean, it's bad. It's very, very bad idea to lie, okay? To not present something during those interviews. Whether it's visa interview, whether it is asylum interview, green card interview, naturalization interview, whatever it is, it's really, really bad idea to provide misinformation. All right, let's just say that. I'm not going to say a lie. I'm going to say misinformation. It's a very, very bad idea, because if that stuff comes up, it's going to be much worse. The consequences will be much worse. So you definitely don't want to do that. And even if you do that, here's the thing. If you don't say that you're married, you go for an interview and you act like you're single, and you go through the interview and you get your immigrant visa and you come here. Here is the thing. At some point, you still have to file the petition for your wife. That is, if you still want to be married, you'd have to file the petition for her to come here. And in order to file that petition, you will have to submit all your marriage certificates, all of that sort of stuff to USCIS, obviously with the I-130 petition, the same thing that your father did for you, all right? So if you're doing that, if you're submitting the marriage certificate, obviously it shows the date that is earlier than the interview at which you said that, oh, I'm not married. It becomes a mess pretty quickly. So you definitely don't want to do that. So, man, and okay, let's look at the other option now. Okay, the other option is you go for an interview and you bring your marriage certificate and you say that you wanted to make an update to your case because you haven't been married and now you are married and you're providing the marriage certificate. The same way they look at your marriage certificate and it's dated before your petition was filed. So at the end of the day, really the only option is to say that my father made a mistake and here's my correct, information. Here's my marriage certificate. I was married. But here's the thing. Here's another problem with this situation, because if you do that, if you come out with all your cards wide open and you say, tell the truth, which is what you would want to do, all right? Here's the problem. Your petition was processed as an unmarried category, unmarried sons and daughters of U.S. citizens. If it was processed as married sons and daughters of U.S. citizens, it would have taken longer. The immigrant visa would not be available to you at all. Well, not at all, but at this very moment right now, it wouldn't be, because you would still be waiting for an immigrant visa to become available. Because there's a significant difference if you look at the F1 category, unmarried sons and daughters over 21 of U.S. citizens, and F3 category, married sons and daughters. If we look, let's say, at the filing dates, so F1 is August 2016 and F3 is November 2009. That's 7 years. So you would have been waiting. If your father filed for you as married, you would have been waiting 7 more years for an immigrant visa to be available. So, you need to find a way. In this situation, it's very complicated. And I gave you this option, I gave you this option. None of these options look good. You need to figure out the way. The best case scenario, if you can find that best case scenario, would be to still go to the interview and tell the truth, and at the same time not get denied, and not to compromise further you petitioning for your wife. Okay? Which I don't know. It's a tough situation. I would recommend your father reaching out. This is what I would recommend. This is what I would recommend. Talk to your father. Talk to your father, explain the situation. Tell him that you're married and you were married when this petition was filed. I know it might cause some friction in the relationship, but it is better now than later, because eventually he will find out anyway, all right? And it's better to start with your father compared to, USCIS or NVC or the embassy, because that's just, it's going to blow out. So once you tell your father, if everything is good, if the relationship is good, hopefully, just be gentle about it. Explain the reasoning why it happened. I'm sure you have a good reason. I'm sure there's a reason for things that we do. Explain the situation to your father, and then the best thing to do for your father, it would be to reach out here to immigration attorneys. Immigration attorneys, specifically family immigration attorneys, specifically who work with I-130 petitions. Their main field is I-130 petitions. A lot of good immigration attorneys, they provide free consultations. So I would recommend for your father to go, 3, 4, 5 different free consultations. Yes, it takes time, but it doesn't really cost anything. But get that professional legal advice, because what most likely will have to happen is the attorney will have to send a request to the NVC to basically request reprocessing of your case based on the newly acquired information. Say that there was initially a mistake and that this person is not single, is married, and needs to be adjusted. So that's a few suggestions that I can give you. I wish I could give you more, but this is pretty complicated situation. Probably one of the most complicated situations that I've seen so far on this channel, in these videos. So if you could please update after some time, after you figured it out, because personally I really want to know what happens with your case. And please, if you do decide to post an update for your situation, don't respond to my comment here. Submit it as a separate comment, because then I will definitely see it and we're not gonna miss it. And I really want to know what happens with this situation. But I wish you luck with this, and I wish you strength to do the right thing in this situation. All right, let's move on to the next one from Claudia Forbes. Good afternoon. Good afternoon, Claudia. If your mother-in-law filed a petition for a marriage son in 2014, how long do you have to wait for it to come through from the Caribbean? Okay, so whenever it comes to the Caribbean, it's in all chargeability areas. So if a mother-in-law is filing the petition, so she has to be U.S. citizen, because she's filing from, well, yeah, no, 2014. If it's in 2014, it's just most likely U.S. citizen. For a married son, so it's going to be, I'm assuming, over 21, the son. So married sons and daughters of U.S. citizens, that would be F3 category. All right, so F3 category, if we look at the visa bulletin, this is the most recent bulletin, and they filed it. She filed it in 2014. So right now, as of right now, they are processing, where's the dates of filing? There you go, dates for filing. They are processing the petitions that have been filed with USCIS back in November 2009. So between your case, well, your mother-in-law's case, and what is being processed as of right now, April 2023, this is the most recent visa bulletin, right here, is 5 years. So very rough estimate, because things might speed up, things might slow down, but very rough estimate, about 5 more years for the immigrant visa to become available. But if you do want to learn more about the visa bulletin, I've just uploaded today a video, the most recent video, specifically on April 2023 visa bulletin, where I talk about different categories. I explain the categories. I explain what these two different graphs mean, chargeability areas, and of course what these dates mean and how to roughly. It's always going to be rough estimates. Why? Because next month there's a new visa bulletin that comes out every single month. So things might speed up, but they also might slow down. So keep that in mind. Okay, so let's move on to the next comment from Superstar Starkaba. Probably mispronounced it, but I'll try it. Thanks for your info. You're very welcome. Thank you for watching. My question is, why are there no movement for family petition I130 F3 worldwide visa bulletin? That is no movement for almost 3 years now. And when will there be a movement for I130 F3 visa bulletin family-based petition? What we are hearing is no movement and no movement. And why is it that employment base is faster and also they have movement every month? Okay, excellent question. So unfortunately, and I was just talking about it today earlier in the April 2023 visa bulletin update. It's ridiculous. It's ridiculous, and this is how we started this video, you know, with a comment from Ireland about just how ridiculous this is. The reason why there is no movement is because, well, there are a few reasons. There are multiple reasons. First of all, the system itself is ridiculous. Why? Because there is a cap. There's a cap on the amount of immigrant visas that can be issued each year. All right? Which means that if there is more applications than there are visas available, you have what they call a backlog. All right, so let's say you have 10 visas that you can issue, right? 10 visas a year, let's say, roughly, just for estimate. And then there are 20 applications. So 10 of them are being issued. The next 10 are transferred to the next year. The next year, if the Congress decides, because that's who makes the decisions, it's the Congress that makes the decisions, which people, like again mentioned by Ireland, most of these people have no clue what they're doing. Whenever it comes to immigration process in general, they have no idea. For them, it is CNN, MSNBC, it is politics, it is votes. All right, that's what it's all for them. But let's say it's transferred, 10 is transferred to the next year, right? And the next year the numbers don't change. It's still 10 immigrant visas that they can issue. So they issue these 10 immigrant visas to the applications from the previous year, but this next year now there are another 20 applications. So now you have a backlog, not 10 but 20. So you move on another year, it's, let's say, again 10. Again, they give out 10 immigrant visas, and then there's, let's say, 25 immigrant applications, petitions come in. So now there's a backlog of 35, and you see with this kind of stuff, and it really is what is happening now. You have more petitions coming in each year than there are available immigrant visas. So with each year, you would think you would get stuff processed faster, but instead it's becoming slower. Why? Because there's more and more backlog. And of course, a year and a half ago, 2 years ago, we had this whole dumb situation with the pandemic, so they completely stopped issuing the visas. So people were just sitting there and waiting, just waiting. So on top of the existing backlog, we had this artificial backlog that was added by this whole pandemic situation. So I wish I could give you some better news, but that's just the way things are. The system is broken. Indeed, it is broken. All right, so I'm gonna address one more comment today because we're already getting past the 30-minute mark. The question is from, I'm gonna put more here, from Iram Wajahat. Probably mispronounced it. I'm very sorry if I did. Hello, my spouse have applied for I-130 for me and our children, twin boys. And our case is qualified since March 2021. Congratulations. And still waiting for interview. Is there any chance to come interview in this year? Is there any option to expedite the interview date? Is there any option for any other visa to apply? Okay, so let's start with the very first question. Is there any chance to come interview in this year? Yes, there definitely is. And as of right now, as of literally yesterday, the brand new visa bulletin for April came out, and the F2A categories, that's one of the categories where the immigrant visas were current, now they're on the backlog and they're about 2-3 years behind. So in your case, it's 2021, so you're about 2-3 years. If you're 2-3 years behind, 2023, 2024, you should be hearing about that interview getting scheduled. So there's a high chance that you will be scheduled the interview this year. Now, is there any option to expedite the interview date? Yes. So if your petition was already approved and the immigrant visa is available, you can submit the request to expedite with the NVC. Unfortunately, a lot of times it is hard to tell if the immigrant visa is already available for your case or not. So, with that being said, I would still recommend submitting a request with the NVC to expedite the processing. If they review it and they deny it, well, you tried. But if the visa is available, there is a chance that they will expedite because you are, you are filing for spouse and 2 children. So I mean, I can't say because I have a petition myself for a sibling, and I want to see. I'm sure somebody wants to see their sibling as much as somebody who wants to see their spouse and children, but still, spouse and children, that is kind of immediate family. So you do have definitely chances for this for expedited processing. So I've done a video specifically on how to request the expedited processing with the NVC, which is pretty straightforward. All you need to do is cover letter with the explanation why you're requesting the expedited processing, some evidence supporting what you're requesting, and then email it. So video is on this channel, check it out. And to answer your question number 3, is there an option for any other visa to apply? Yes, absolutely. You can definitely apply. You can have your spouse apply for a non-immigrant visa based on a very simple invitation from you, saying that, hey, look, I'm in the United States, I'm a permanent resident or a U.S. citizen, but I'm pretty sure you're a permanent resident in this case, considering the times, the waiting times, and then saying that, hey, I clearly want to see my spouse and I want to see my kids, and then they go to the U.S. Embassy over there and then they request non-immigrant visa while you are waiting. Another option would be a K3 visa. If you are a US citizen, you can do the K3 visa, which is non-immigrant visa for the spouses, specifically for spouses of US citizens. But again, there is really not much difference. Just keep in mind that because you have an immigration petition and you have your spouse going for an interview for a non-immigrant visa, they might see it as a contradiction. And if this US embassy is in a country where it's hard to get the non-immigrant visas, like for example the country where I'm from, it's really hard to get a non-immigrant visa, so there's very high chance of denial. And especially they look at stuff like this when there is an immigration petition, because you already have the intention to immigrate and now you come in to request the non-immigrant visa, which is, it can be seen as a contradiction. Honestly, it shouldn't be, but it can be, just so that you were prepared, just in case. But I really hope that it is scheduled sooner than later for you, and I hope I was able to answer your question. And everyone who was asking questions today, I hope that this video was helpful. If you have any follow-up questions, go ahead, submit them in a separate comment, and I will be happy to address them. As always, thank you very much for watching. Always appreciated. God bless, and I'll see you in the next video.